Well, Vishal will be here in just a moment to introduce us. So in the meantime, I will introduce myself, and then as I can as well. So I'm David Sanker, and I'm currently working as a patent attorney. I was working 20 years approximately at Morgan Lewis, and I recently left Morgan Lewis to launch my own patent law firm, Sanker IP, and so we are growing. And in the area of AI, I've been recognized twice as a top AI attorney. So that's always useful by the Daily Journal. So I'm here to talk, and I talk and present on AI topics, particularly for intellectual property.
I'm Shashank Bhatia, and I started this boutique practice almost 15 years ago. Have a background in chip design, electrical and computer engineering, studied in Texas, worked in the Bay Area, and really stumbled into the IP world. I do specialize in software and semiconductor-related patents, and interestingly, the last couple of years, I've been doing a lot of patent work in the data center space, where they are not just servicing AI, but they're using AI. So by virtue of the fact that they're servicing AI, there are extreme challenges when it comes to cooling, because they're using GPUs, TPUs, etc. And another company that is using AI in the mental health care space.
So I'll just kick it off with, I have a few slides to kind of introduce the panel. I have a few slides to introduce the panel. I just want to request that they be put on. All right, so as my colleagues have already introduced themselves, we are going to talk about patenting AI, friend and foe to innovation. And what I wanted to just do in a couple minutes is set the context, because this is such a broad topic. There's so many things that one could cover in there, so I'm just going to kind of put a boundary around it, a pretty big one, which at least gives us all an opportunity to think about what patenting AI means. And as in the previous session, it would be great to have everybody kind of put on their mental hats and come up with questions to add to the discussion. So one of course perspective which we heard this morning was, is it all really much ado about nothing? So the first thing when we have to think about patenting AI is to start decoding what the word means. Are we patenting granular technologies that are the building blocks of, in quotes, AI, and AI itself can be a very broad thing? Or AI we are talking about patenting is the one that actually contributes to inventions in other areas. So these are the kinds of things that we hope to tackle in the panel, so I just want to lay out the groundwork. And then of course the question might be, well, what's to patent? Can we say that AI today is basically sitting on technologies that are already patented, and there are millions of patents on those technologies, and AI is just but additional software? So is there anything to even patent? I'm sorry. And then, is it really tectonic shifts that we are thinking about, or is it incremental glacial movements? I mean, will a lot of patenting AI simply be innovations from incremental improvements, where we are using AI to just do things, in quotes, better? So that's a thought to think about. And then, what is going to be the role of regulatory frameworks? We heard this mentioned in the morning. We'll dive a little bit deeper into it in this session. Like, will the executive order from the Biden executive order or the EU AI Act, will they impact patenting of AI or AI-assisted inventions? And then what will the impact be? Will it impact what can be patented, or will it impact how it can be patented, or both of the above? And then we have to rethink about what AI inventions are and the role of AI itself as an inventor, right? So in patenting AI, what happens with inventions that was a result of AI processes that contributed to the invention, right? Or how should the inventors and patent attorneys think about patentability in such a situation? You have to think more creatively about how to patent a new idea when AI has been involved in its creation. And then, does the role of the patent attorney and the inventor become more critical when it comes to patenting AI or inventions that are assisted by AI, or more importantly, inventions that are for AI itself, where we are talking about the AI value chain, which is what I started with earlier. And what if AI was indeed allowed to be the inventor? We've heard that thrown around. How would the legal issues of enforceability and accountability work? And what would be the ethical and human dilemmas of allowing AI to be an inventor? And I think my colleagues have some interesting viewpoints on that we'll try to dive into. And then finally, again, going back to square one, what is AI? After all, it's just the handiwork of millions of humans and tens of billions of dollars. So it's simply a collaborative effort of millions of humans. So no invention can ever really be attributed to it. I mean, that's one viewpoint. But there are nations that are, in fact, close to attributing inventions to AI, and we'll talk about them in South Africa, Australia, perhaps, but in what sense, really, are they doing that, and whether the issues will, we're just kicking the tin can down the road. And then what are the guidelines for patent office guidelines for AI, and what is going to be their impact? And finally, is AI just a tool like hundreds of other tools over the course of human history, advancing the cost of innovation, and it's just kind of acquired a life of its own because of the way we've thought about it as a society? And does it really even have the capability to build something independently of human intervention or human inputs? I mean, as we discussed, it cannot really create claim charts or maybe even draft a patent application yet. So can it really build something? And so that's kind of, the kind of universe that we are hoping to cover in the rest of the discussions. And I laid it out there both as a groundwork for us to work off of and for you as the audience to kind of have a sense of what your thought is on some of these. And as in the previous panel, we intend to involve all of you in sharing and in discussing. So with that, I'm going to just kick it off and start right at ground zero, the decoding of what patenting AI means. And I throw it open to both David and Shashank to chime in.
Okay, I'll start, and then he can correct me for everything that I say that's wrong. So really there are both, because there are some people who really are innovating of the AI itself, particularly in the hardware. I don't know, some of you may have gone to the AI hardware summit just this past week, and so there's a lot of innovation in the hardware that's being used for AI. For my practice, though, most of my clients are just using AI as a feature for some other invention, whether it's in new drug discovery or anything else where you're sort of saying, okay, at some point in here where maybe without AI, it would take longer or not do as well, you apply AI to do something that is either better or faster in some way. So most people are using AI. And then it becomes a question with like, well, how can we actually protect that? And because some people say, well, we don't know what's going on in the AI, so how can we actually claim that? And that's really an important question, because the way I generally answer that is that you're looking for things other than just the AI itself as the inventive aspect. What did you do in terms of how you trained it? Did you modify the data? Did you do something else in the training process, or after you've trained it and are using it? So usually say, okay, just applying AI, that's not going to get you a patent, but depending upon how the other aspects of your overall invention, that can get you to patentability.
Right. So the building blocks of AI are all patentable, and there are thousands, like you said, millions of patents around it, whether it's hardware, software. You know, software in Europe has to have a technical aspect to it. In the US, it has to, there's an abstractness clause over there. There is algorithms, mathematical models, obviously, which you can't patent independently. But I actually think application-specific AI, for example, the patent drafting thing that we talked about, okay, that is not a generic piece of AI. So now if that were to be developed where the AI can turn out experienced quality patents basis incomplete disclosures, can second guess what the inventor is thinking, then that, in my opinion, is application-specific AI. I'm also working with someone in the mental health care space, and they have these phenomenal algorithms that they've developed. Now, algorithms per se you cannot, but when you're talking about systems which are made to function by those algorithms, you have a very powerful value proposition. So I actually think that application-specific AI may be patentable, but AI in itself, like you said, is a very, very vast term. You know, really, what does it mean?
Yeah, I mean, there's the entire value chain,
Yeah.
right? Hardware, software, infrastructure, includes data centers, energy efficiency, I mean, the whole gamut. And of course, AI has thrown up specific problems in certain areas where innovation is happening. I mean, you talked about data center,
Sure.
energy efficiency. I
Sure.
mean, that's been necessitated by AI.
I'm glad you reminded me. So this is another thing, the data center company that I'm working with. You know, they are using GPUs in their data centers to service AI. And what is the problem they're facing is cooling. You know, now cooling because these generate a lot of heat. So what they're doing is they are liquid cooling these data centers, and unique ways of using that heat is creating unique opportunity to create more intellectual property and and increase the patent the patent valuation. You may have core and non-core patents, but there is definitely an opportunity where you are looking at converting one form of energy to another and increasing efficiencies that way.
Yeah, so it seems like AI is definitely spurring innovation in some sense.
Well,
so maybe it's not that much of a foe after all.
Yeah, but you know, if you think about it, every single breakthrough disruptive innovation has thrown up new challenges. The mainframe computer, which was the size of a building, led to the need for a desktop, which led to the laptop, which led to challenges with battery technology. And when they perfected battery technology, they realized they could use it in electric cars. So, every single innovation is throwing a new challenge and a new opportunity.
So let me throw it to the audience. Does anybody have a thought right at this stage of the game itself in terms of, what patenting AI really means to you? Have any of you been involved? I mean, I know earlier a lot of people raised their hands that they're actually attorneys and involved in either litigation or prosecution. So has anybody actually, in the recent past, done patents that they would term as patenting AI, and can they share maybe an experience? And I see a hand raised, so could we get a mic here, please? I don't know why. Why don't you just, let me get you my mic.
I've done some machine learning patents, but I haven't actually done like dedicated AI patents. I have sort of a broader question from a litigation standpoint, since that's most of the work that I do. I think, as we all know, the federal circuit and federal courts are extremely skeptical of anything that looks like an abstract idea. They've gotten very aggressive. A drive shaft, as we all know, is an abstract idea, apparently. And I think the way it's often formulated is, if a human could do it, you can't patent it. And since AI is fundamentally trying to get a computer to imitate a human, how do you sort of deal with that idea? I mean, I know there's the sort of application-specific approach, but if you could just kind of speak to that specific challenge, I think that would be interesting.
And this is actually, in terms of the overall concept of this particular session too, it's like, friend or foe, the sort of regulatory or legal framework has a big effect on this, and so there's a question of, well, so patent particularly patent prosecutors like me deal with the issue all the time about, well, can you even patent that? It can be done in the human mind. Theoretically, it's supposed to be, well, can it be done practically in the human mind, which means that, if it could take me, 20 years to do it versus a computer, that's not practical. So theoretically, that should be the norm, but not all examiners are applying the norm in the way that it's intended.
No judges think that way on this solution.
Okay.
If it would take a human a billion years to do it, and a computer can do it in 2 seconds, a judge would say, no, a human can do it. No.
Okay. Yeah. And I think this is actually an important point, because if it remains sort of a de facto standard that, the fact that a human could do it in an infinite amount of time means that it's not patentable, then that's actually, I think, a problem. And that's a very big hindrance to innovation, because other countries are being a lot more helpful to their innovators to get patents. And so I think if that remains a standard, I think that's actually bad for innovation in the United States. And so in terms of my working with examiners, I've seen a wide variety. Some say, that is a small hurdle. Others think it's really big. And I'm trying to get a hold on this right now in terms of, well, should it be or not? And actually, right at the moment, there is the subject matter eligibility guidance specifically related to AI that was released, I think, mid-July, and the USPTO asked for comments about that. Originally, it was due mid-September, but they gave another month. So I'm actually working on responding to that, because I want to make sure they're realizing, yeah, this is an issue, because sometimes the USPTO is sort of disconnected from the reality of what's happening at the examination level, and I want to make sure that they're aware of that. And if you have thoughts, I will be submitting a response to this. So if you have thoughts that you want to add to it or join me, I'm happy to do that.
Right. So human behavior is different from AI, let's say, behaving like a human to achieve a technical result. And I don't know, like you said, the judges see it all as human behavior, but the way I see it is that AI may be replicating to some extent human behavior, but if it is achieving a result that one can demonstrate is actually a technical step, then I think we have something in the realm of patentability.
Yeah, and that brings to open the question that if it's again put just in the regular software bucket, then all the biases of the abstract idea of software and all of the battles we've had over the last decade kind of flow into AI without really giving it a chance to be recognized as there are aspects of it that are not quite the same, as we've talked about in the earlier panels. And I think it's just going to take some time for it to tease out. Maybe there'll be some horrible cases, some tough battles which will bring out some of this, unless the regulatory framework is able to advance it. And I don't know if you guys have, or even anybody in the audience, what the feeling is from our friends in Europe and elsewhere, what the regulatory framework is doing in Europe or in the UK to kind of bring out or facilitate some of this. I mean, I know Jacob talked about the fact that it's a little bit easier in the UK right now, although it's changing.
I've got sort of another question, I guess. When you're drafting like an AI-related invention in the US, would you really try your best to avoid ever using that sort of language actually in the claims?
Avoiding what?
Of artificial intelligence, machine learning, would you always try and steer clear of actually using that specific language
yeah,
when you're drafting the claims?
Generally, you don't want to actually say, use AI to do this. On the other hand, you do have to say, like we'd say, for claims that are devoted to more the training process, you can say, training an AI. I mean, I guess maybe sometimes, training a model, and you may or may not say AI, but so training a model according to, and then other claims say utilizing a trained model to do something. But yeah, putting in just AI is not going to get you any advantage, and may make it tougher.
I was actually going through some patents that were drafted about 10 years ago, 2012, 13, and software related. And here, yeah, it's gone. Yeah, thank you. And just doing an evaluation the last couple of days ahead of this conference to notice that a lot of what was done then is reading upon what AI products and technologies and services are doing today. So there wasn't even the mention of the word AI in something that was written 10 or 12 odd years ago.
So any other thoughts?
So talking about sharing experience about AI in patent application or litigation, I'm actually helping a client that's mapping their AI patents against their competitors and trying to figure out that what their competitors doing and whether they infringe their own patent portfolio. And the difficulty we met is that everything is hidden in the server, so we don't know what's happening, inside that. Now, the Chinese client, I'm from China, and then in the United States there is discovery. So when you have a litigation, it makes it easier to prove infringement. But at the initial stage, I believe it's the same. It's really hard to figure out, whether that's your competitor infringe your patents or not. You don't want to look silly after you file a complaint. So I was wondering whether anybody experts have experience on that, how to, any experience or tricks to overcome that. Thanks.
That is actually a really good point, and I mean a good patent attorney should be thinking about that, because you really have to say how easy is it going to be to identify an infringer and collect the data, because do you really want to say, I think they might be infringing, let's file a lawsuit, spend a bunch of money, and in discovery determine whether they're actually infringing or not. I mean, that's kind of could be a very expensive fishing expedition. And so an important question that we have to ask is, like, depending upon how easy it is to prove infringement, you may actually want to protect it as a trade secret instead. And that's an important consideration. And sometimes it still makes sense to get a patent, but I think it's really an important consideration as to, well, how easy is it to identify infringers, as well as kind of along the same lines. It's like, how easy would it be? It's like, if I'm deploying this, how easy is it going to be for people to see what's actually happening and reverse engineer it? And if it's not easy for people to figure it out, I mean, why file a patent application at all? So I think that's an important question.
I'm not a big fan of trade secrets in the tech space, because things are not so difficult to reverse engineer. Once you figure out how a system works, you may be able to, you may end up using an alternate means in order to get the same result. And this is a big challenge wherein when you draft claims, are you able to draft claims in a manner that is able to read upon detectable forms of infringement through maybe an interface or the end result of a process, or how a system actually works? Because I can understand a trade secret like Coca-Cola, but in the realm of software and hardware, you could achieve the same system using many different programming languages.
And there was a question. Yes,
quick
ma'am.
comment. Basically, bringing back to the challenges of drafting. So I'm a patent prosecutor, and we have used the word model, because the entire specification is talking about a model in the AI context, right? So we are not always specifically saying that it is a, AI model, a model that uses AI to somehow draw inferences. But the examiners are looking at the word model in the claim, and I'm talking about specifically semiconductor industry. And in semiconductor industry, people are using process models for a long time, 10, 12, 20 years. They're citing 20-year-old, semiconductor processing models, saying this is what is making your thing obvious. So we are like battling with the examiners, saying that you cannot just independently interpret the word model. You have to interpret in light of this specification. So, and there, we are engaging in a lot of interviews with the examiners, and we're making, baby step progresses, but it just gives them an excuse to kind of stretch the prosecution, generate another request for continued examination RC fees. So, recently I had the chance to talk to the director of the regional patent office, and we try to share the prosecutor's pain points with the USPTO, that your examiners are just being unfair, So I think it's very important to any chance we get as practitioners to kind of share our practical experiences with the examiners, with the decision makers at USPTO. That's kind of a request to all the practitioners out here that, share your practical pain points with the USPTO personnel. That will advance it, because, they're pretty, when you meet them in real life, you'll realize that they're not your enemy. They also want to.
Most of them are not.
Yeah. So just wanted to throw in that comment that the more you kind of, meet an USPTO personnel in a setting like this, an event that is of interest to both the government side and the practitioner side, try to share your practical experiences with the examiners. That will.
No, I've had this experience with many examiners where they're not your enemies. They actually want to help you.
Right.
They will tell you when they're giving you a rejection.
Right.
They will tell you what kind of amendments will put your patent in line for the likelihood of allowability. And I've had this several times where I have got allowances based on examiner recommended amendments.
Yeah.
But that is a very, very important and valid point, because it's going to work. It's a double-edged sword. The examiner has the ability to now find a much larger pool of patents, and again, which we talked about in the panel in the morning, put stuff together and say this is obvious, this applies, or this particular verbiage makes sense. Although that is a common problem I've seen in the USPTO examinations over the last 15 years. So it's not a new problem, but it'll probably get exacerbated because now they have much wider searches. Right. But by the same token, hopefully, as you said, the dialogue will help people recognize that you really have to put things in context, and you can't just take disparate concepts and try to assemble them as a potential prior art and a basis for rejection.
Right. And just the last comment is we used to do all this fighting in written format before. Like we'll quote like a section from MPEP, the manual, and it would like take a very formal sort of adversarial posture. Now we don't do that. We just engage in interviews and have a human conversation, and then say, as discussed during the interview, this amendment is likely to overcome the rejection, something like that. So you don't necessarily create a lot of paper trail that sounds like, we are talking horns.
I completely agree with you. And I remember in the early stage of my career when I was writing responses, and I would draft these elaborate responses that I thought were just fantastic, and surely the examiner is going to agree with this. Rarely did it work. Having a good conversation with an examiner, being open to listening to the examiner can make all the difference in the world. So it's a two-way conversation. I'm trying to help the examiner understand the invention, and the examiner is trying to help me understand how he or she is looking at the claims, and those conversations are very helpful. So just like in the AI space, it's just as valuable as any other patent application. Yeah, your methodology is exactly right.
And because on a funny note, even AI does not like adversarial input, and that's not even human. So, anyway, so sort of jumping off of that, I want to bring it home to a related concept, which is like, what do you guys think about the notion that, or the argument that, well, AI is just sitting on already patented technology, so what's to patent? Do people have a thought? Have a thought?
The interesting thought that occurred to me on my way here, actually it's a significant thought, is that the fact that it's sitting on patented technology is fine, and the patented technology continues getting patented. There is incremental innovation taking place. You know, GPUs, TPUs, architecture, you know, software, etc., etc. But what is interesting and what is actually significant is, as AI self-learns and AI evolves, that self-learning part, which is attributed to AI, you know, is that patentable? Number one. Is that an invention? Number two. And whom do you attribute it to? The builders of those systems that taught AI to evolve itself? You know, because I find it a stretch to attribute inventive credit to AI. Okay, so if not inventive, I say patentable credit to AI. So let's say AI does invent, and AI does improve itself. Now, even if it is an invention, in my view, it ought not to be a patentable invention.
And why is that?
Because with patentability comes accountability and responsibility. Now, we were talking about AI, hey AI, build me a better drug for diabetes, okay? AI builds you a better drug for diabetes, everybody goes home happy. But AI builds you that drug for diabetes and people die when they take it. Are you going to prosecute AI? You know?
If AI was the inventor.
If AI was the inventor,
Yes.
because AI going perverse, you know, if AI goes perverse, let's just hypothetically say if AI goes perverse, somebody has to be accountable, and that accountability cannot be attributed to a machine. You know, a knife was invented to cut, and a knife was invented to kill. Somebody used that knife to kill. Okay, are you going to sue the knife?
I think a friend from Greece has a comment, because he got a thought the moment you said something. So let's get that while
Sure.
it's still fresh.
Totally agreeing with the this way of thinking. That's why it's important to ensure that there are always humans in or on the loop.
Yeah.
Because you can patent maybe the original algorithm of a self-learning AI technology, but you can't patent the way it's applied or deployed. So you have to have some human that is responsible in every stage of its evolution and application. And that is where you go with possible prosecution and litigation.
In fact, I would like to throw a question to David here, because that goes back to, again, the frameworks and the guidelines that are available. And I don't know if you have a thought on whatever we are getting so far, you know, are they providing enough of a boundary box to allow that without stifling things?
Right. So I mean, and in this in the context of whether AI is inventive or not, I think we might actually slightly disagree on this point. But to my mind, like if you do sort of acknowledge that AI is inventive, which in some sense, the USPTO and there was a recent decision out of Germany as well, High Court in Germany, that essentially came to the same conclusion, which is like, let's just kind of ignore what is being invented by AI, or whether it's even inventive or not. It's just like, just ignore that and just say, was there a sufficient human contribution to make an invention, in which case it's fine. And so it's focused on the human aspect. And I think for right now, that's exactly the right answer, because the law is not there to say that you can allow an AI inventor. So the law certainly doesn't permit it. And so the right answer right now is certainly to say, okay, let's just make sure the humans have done it. On the other hand, I'm not necessarily antagonistic to saying, yes, there was an AI inventor here. And if you do, though, the key thing is, it's like, well, who is both the owner and then responsible for it? And those two would go together. So if I am the big drug company that creates this new drug that was invented entirely by AI, well, it's like, I'm getting the profits from it, so any harm that comes from too,
yeah.
it's like, you be responsible for the harm as well. And one thing that
That's a great point, actually.
yeah. And one thing that I would say is we're not as far from being able to permit AI inventors as you might think, because the USPTO already allows to deal with a situation. Well, what happens if an inventor creates something and then dies? Does the invention disappear? No, there's a specific statute that says, okay, here's what happens if you've got a deceased inventor. If you've got an inventor that's unavailable, if you've got an inventor who is, become mentally incompetent. We've got situations to deal with that. And so it's not a huge stretch to say, okay, well, we could have this AI inventor as well. And it's basically some other entity has to get the rights to the invention, which also has all the responsibilities as well. Yeah. Well, actually, you've got a question here first.
I want to come back to the previous point, responsibility.
Yeah.
And I think if a car accident happens and AI is responsible, the humans say, okay, this was machine who was responsible, the human should do it. And if a human has done it, you'll say, oh, it's a human default. That means this kind of thinking, because maybe the car accident nevertheless happens. That if a machine is responsible, it's wrong. But if it's a human default, okay, it's some kind of acceptable.
Allow me to build on that thought. I agree with you, and I agree with you as well. That's a great point you made. But think about AI having invented this drug. This company makes billions of dollars on it. A tragedy happens, and this company deploys now AI 2.0. And it's the owner, but it says that AI doesn't work for us anymore. So, it's a bit facetious. I know I'm being a little frivolous over here, but the point I'm making is that it is very easy. It is very easy for humanity, and humanity has had this tendency to shake off accountability. And ultimately, laws are meant for humans. It's like the chimpanzee who gets the copyright for the photograph that he took. But what if that photograph was infringing somebody else's copyright? Can that chimpanzee be sued for it?
Guys, with respect to the pharma cases, as we have been talking about, that if a pharmaceutical company invents a drug with the support of AI, let me highlight here that that drug will not be patentable, because ultimately they have to go for the wet lab experiment. How AI has been supporting the pharmaceutical company is in screening, shortening the screening process. But finally it has to go for the wet lab. It has to go for all.
No, that point is well taken. That's a technicality. This is actually more at a philosophical level, whether AI should be attributed, the credit of inventorship or not. I completely agree with you. The wet lab, the testing, the FDA approvals, all of that. I mean, the AI, if the ownership, even the statement that I made, was a slightly more facetious one, where, if the ownership is mine and AI has invented a drug, but I own it and I've made money on it, the responsibility is also mine.
Correct. And
It's
if you
not
look
AI's.
at the recent law by USPTO, it says that there has to be significant contribution by human with respect to proving the practical application
Sure.
of that particular invention.
Yeah, exactly. So the rule as it exists now is that you have to have at least one human making a significant contribution, and so the question that needs to be fleshed out more is like, what constitutes significant enough to be considered a human inventor? And that's something that the USPTO asked for comments on. And I brought up some issues about, I submitted some response to that to say, there's some issues with that. And why is it complicated? And I'm actually working on some that say, now it's like, okay, well, let's try to help out a little bit, because we need to know more. It's like, because in order for, going back to our original point, it's like, friend or foe of innovation. It's like, well, in order for it to be helpful for innovation, we have to know. A company that's going to invest a lot of money needs to know, it's like, is this enough effort by a human to be considered an inventor? Because they need to know that they're actually going to be able to get a patent. They don't want to discover in litigation 10 years later that's like, oh, well, you know what? You don't have a human inventor, therefore you don't have a patent. And that's something that I think is likely to occur in the next 5 to 10 years. We'll probably see something where it's litigated to say, oh, the argument is that, oh, the human parts were just small, and the real work was done by AI. And it'll be interesting to see what our litigators do with that on both sides. It should be interesting to see.
Yes.
Further elaborating to this discussion, although the comparison with the incapacitated inventor is logically...
The comparison, can you just repeat that?
The comparison with a capacitated inventor, like an inventor who is dead or mentally incapable, is logically reasonable. Legally, it's a different thing because...
Oh, yeah, yeah.
Because if we... even these inventors, the incapacitated ones, are physical and natural and legal persons. So if we make this comparison in the legal world, it's like indirectly recognizing AI's personality, possibly. And if we do that, do we recognize it for a specific algorithm or for AI in general? That
There's
makes other liability issues and philosophical ones as well.
Absolutely. Also, the inventor has the choice when applying for a patent to be both the inventor and the assignee. Can AI refuse to assign its invention to the pharmaceutical company for which it makes $1 billion?
Yeah, I agree with you. The point is to say it's something that sort of this notion sort of exists, but it would require a change in the law, and there's some significant issues to deal with, and one of which I've to my mind is actually, and I think you may have brought this up, which is like, well, like, let's suppose that you've got an AI system which can be inventive. Well, an AI system is implemented in software, and therefore you can easily replicate it. So there could be 100 or 1,000 instances of essentially the same thing. Is that one inventor, or is that a bunch of different inventors? Because if it's a bunch of different inventors, then an invention by instance A could be used to invalidate one by instance 2, 3, 4, and so there's a lot of complexities. That I think would need to be addressed, and who knows whether our lawmakers will ever want that. They may just say, you know what, we always want human inventors, and they need to make a significant contribution. So it could be that way forever.
So on that note, I have a naive question, which I've always had, and some of us may agree on that. I mean, given all of this, I mean, instead of diving into this, why is it necessary? I mean, unless you are patenting, like you said, the AI model, etc., and we've talked about that. If AI is assisting number of different verticals, we've covered the whole gamut from semiconductors to telecommunications and bio and everything in between. Wouldn't it be, as I was thinking, the job of the patent attorneys and the inventors together to formulate an intelligent patent application where, I mean, why is there a need to always throw in the AI? I mean, the AI has a supporting role, as do hundreds of other technologies. So why wouldn't it be all in the way the patent is drafted? And I mean, unless, like we said, I mean, the patent office sees, hey, you used some kind of a software model and it asks for more details, the goal would be to create a patent that covers the most inventive aspect of
at a more primitive level, you know, the technology for, let's say, internal combustion engines, we discussed this, has evolved and leapfrogged over the last 100-odd years. Would somebody at Mercedes who uses simulation and computer graphics and all of that stuff, processing power, in order to develop a very sophisticated engine, attribute the invention of that to the computer system that he used to develop that?
Oh, exactly. What does the room think? We clearly don't do that. Yeah. So, I mean, is it just we are in a passing phase? You know, 10 years from now, it'll be a given that you've just used, you know, AI-based assistance to get something? Yes, please.
Yeah, just I have already spoken, so I'll keep it brief. It's like when you're saying that the inventors and the patent attorneys can come together to draft claims intelligently so that AI has a supporting role. So I'll give a specific example. It's basically workflow automation. That is and the most inventive aspect of it is making it completely an unsupervised decision. Right? But we had to tweak the claims to only claim the semi-supervised learning model because you are kind of forcefully involving a human just as a strategic point, because your likelihood of getting the patent is going up because you're now saying that it's a supervised learning model. That is not the most inventive concept for this invention, but you're just taking a middle ground to increase the likelihood. So we're in a very interesting phase right now. We're disclosing everything in the specification, but choosing the set of claims, the embodiments that has a higher likelihood of getting a patent from the patent office under the current amorphous, framework.
Yes.
But in doing that, I think we're still, kind of creating prior art, published prior art in the space so that somebody else cannot patent the completely unsupervised learning model. So it's an interesting phase that we're in.
So I want to hit, leaping off of that, the notion that there are these countries like South Africa and Australia, and maybe they are close to attributing inventions to AI, but I know that there is more to the story than that. So I'll let David maybe pick it up, and then we'll chime in.
Yeah, just brief. I mean, you probably, most of you have seen this. So Professor Thaler had created the system that he called Davis, and then they filed patent applications throughout the world. And the relatively universal response has been to say, no, you can't get a patent for in the name of just this AI system. So pretty much that's been universal. Initially, Australia, a lower court said, "Hey, we're okay with that," and then, but it was later overturned by a higher court. So Australia is basically with the rest of the world. With one thing that I think is useful, a lot of us who have done patent prosecution work and have filed in Australia know that there's a slightly different system. That rather than just a straightforward assignment system, you have you file a statement of entitlement, which is a little more broad. And so you can file a statement of entitlement that, well, I'm entitled to the ownership of this because I own the AI system or something. And so it's a little bit a broader concept, which I think is maybe if people want to go down the route of allowing AI inventors, that concept is probably a good start if you want to go there. On the other hand, South Africa has a system for patents where it's just as long as you meet the formal requirements, it's just the patent. It's approved. So there's no real evaluation of things. So that's the one exception to the rule. But it'll be more interesting once something actually is litigated in South Africa, because a registration system doesn't really tell us much. You don't really know what the courts are going to think until they actually do that.
Yeah, so the key point is that it's not that it's been approved, it's just that it's just been filed and has made it through the...
Kick the can down the road, basically.
Yes, kick the can, yes. Yeah.
Yeah. This morning when I woke up, in light of this topic, friend or foe, I asked ChatGPT, are you my friend or are you my foe? Okay, and I got some serious responses, but I'll read out 2 lines of the funny ones. ChatGPT says, if individuals or organizations rely too heavily on me for generating ideas or solving problems, they might neglect their creative instincts, leading to a less innovative outcome. Second one, reduce critical thinking. Dependence on me for information and solutions can diminish critical thinking skills, making people less likely to question assumptions or explore alternative approaches. In other words, I might make people lazy. Bias and discrimination. Now, I'll read this. AI systems can perpetuate or exacerbate biases present in the data they are trained on, leading to unfair or unethical outcomes in innovation, particularly in fields like hiring, healthcare, and law enforcement. And then, you have IP issues, you have job displacement, but the most dangerous ones are the perverse ones, the malicious use, identity theft, fake news, stuff like that, wherein regulation, like you said, becomes very, very significant.
Outside the patenting of the AI.
Yes. It's a bit of a...
unless you patent AI for deepfakes or
Sure.
whatnot, and you actually manage to make it through.
Sure.
They're outside of.
There is danger of AI going rogue also, right?
That, yes, that's a whole another possibility.
Sure.
Or, I mean, as you said, it being used in a malicious way.
Yeah.
Which of course can happen for identity theft and other things. Okay, so on that note, I would like to see if there's thoughts from the panel, from the audience, or questions, or.
I think we're 5 minutes over, so.
Oh, are we?
Yeah, we are over time.
Okay, great. Well, I think then that brings us to an excellent stopping point, and we can continue the discussions offline. And thank you very much all for your participation and attendance.
Thank you so much. Now it's time to honor our panelists. So I request Shashank to be on the stage and Dr. Vishal. So on behalf of IIPLA, no, so you need to honor David. Thank you so much. So we can have a group photo for this session.